I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are back in the courtroom of Judge Kristen Simmons out of the state of Michigan for part two of the trial of Moorish National. He doesn't like to be called Sovereign Citizen, only Sovereign or Moorish National by the name of Mr. Aaron Skates. If you have not seen the first part of this trial or the pre-trial, because we share both of those in our last video, please go and watch those first. We'll put a link down in the description for you. Check that out first, and then check this out. And in that first one, you got body cam footage, police officer testimony, his first appearance before Judge Simmons when he had his sovereign citizen head on then and at the traffic stop, so on and so forth. So you might want to check that out to really understand what's going on here, what's happening, and why the outcome is going to be whatever is going to be. Also, are picking up. We are picking up at the point of where they're getting ready to do closing arguments. We left off in the last video at the end of the second officer's testimony. So we are starting here at the closing arguments for both the prosecutor and Mr. Skates. As always, guys, I appreciate you guys for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, comment, share, and subscribe. Now let's go ahead and jump into this courtroom.
So you can be seated. So the people are resting, correct?
Yes, Your Honor.
Okay, so at this point, Mr. Skates, you have a couple of options. Obviously, you have the right to remain silent and you don't have to do anything to prove that to prove your innocence. It's their job to prove your guilt beyond a reasonable doubt. But you do have the right, if you would like, to waive your silence and take the stand and testify. Is that something you wanted to do? Okay, I just wanted to make sure, because understanding if you testify, they have the right now to cross-examine or question you. You understand that? So you do want to remain silent, correct? Okay, so what we'll do now is we'll get ready for the composite instructions, and then you'll be able to do your closing arguments. seated. Okay, and this is the last set of instructions we have, and then we'll allow them to give their closing arguments. So if you want to pay attention to the screen, members of the jury, the evidence and arguments in the case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you ought to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles a defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. Just a moment. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that the defendant did not testify. It must not affect your verdict in any way. When you discuss the case and decide your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence only include the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments and the defendant's statements also are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyer and the defendant said that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they have given meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or to express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. I don't know that we did that. Do not consider those things in deciding this case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have of a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice that you may have based on race, gender, or national origin of said witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or influence that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about May 22nd, 2024 within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your own honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judge, the lawyers, the court officers, or other people involved in the case. As you discuss this case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, Do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take again your notes and a full copy of the jury instructions. If you want to look at any of the, well, in this case, there's only some exhibits and they are a video. So you will have your foreperson write a note and we will make sure that you can re-review the videos if that's something that you would like to do. When you go to the jury room, you will be given a written copy of the instructions you have just heard as you discuss the case. You should think about all my instructions together as the law you are to follow. Notice they say that at least 3 times, back to back. Okay. You may return a verdict of guilty of the alleged crimes or not guilty. We have prepared a possible verdict sheet listing those possible verdicts. The prosecution has introduced evidence of a statement it claims that the defendant made. Before you may consider any such out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court, which the defendant imposed his right to remain silent. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking the same example, if you see a person coming in from outside, wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence may be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, or how he did it, or by any other facts and circumstances in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness or witnesses who are police officers. That testimony is to be judged by the same standards you would evaluate the testimony of any other witness. Again, the element of the crime, obstruction of official business, the defendant again is being charged with the crime of obstructing official business. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant hindered, opposed, obstructed, or resisted Officer Mark or Tyrese McClinton. Obstruct includes the use or threatened use of physical interference or force or a knowing failure to comply with a lawful command. The defendant must have actually resisted by what he said or did, but physical violence is not necessary. Second, that the defendant knew or had reason to know that Mark Fox or Tyrese McClinton were police officers performing their duties at the time. And third, that Mark Fox or Tyrese McClinton were performing their duties as officers of the Lansing Police Department. The elements for furnishing false information. The defendant is charged with the crime of furnishing false information, and to prove this charge, the prosecutor must prove beyond a reasonable doubt, first, that Mark Fox or Tyrese McClinton was a peace officer who was conducting an investigation of a violation of state or local law or ordinance. Second, that Mark Fox or Tyrese McClinton informed the defendant that he was conducting an investigation. Third, that the defendant provided false information regarding that investigation to Mark Fox or Tyrese McClinton in a statement that he that the defendant knew was false or misleading. Fourth, that the defendant acted knowingly and willfully. That is, that the defendant provided the false information voluntarily and intentionally with the intent to deceive, and not because of mistake or something or some other innocent reason. It is not a defense to the charge that the officer was able to obtain the information from another source or by different means if you determine beyond a reasonable doubt the defendant intended to provide false information. And that concludes the jury instructions, closing arguments.
Thank you, Your Honor. So earlier today, I told you the scene, what my theory of the case was in terms of the alleged crime of furnishing false information and hinder, oppose, or obstructing official business. That's what it looks like. To obstruct official business is what you saw. Everyone here knows in defense of themselves or has seen other people be pulled over. You know what a traffic stop looks like, what you're supposed to produce. It's a very standard thing that police officers do throughout their day. As Officer McClendon was initiating a traffic stop and investigating the plate violation that he witnessed, he asked for the typical items that one would ask for. Some of those items were provided, some weren't. And then while he's trying to investigate, he's being obstructed by the defendant's constant barrage of theories. Backup arrives, and the obstruction continues. We're trying to identify who we have now because we're in the middle of an investigation. We can't do that. Instead, what occurs is a false name is given. The officers check that name. First the paperwork, then the name that's actually uttered. Nothing comes back to the system. Eventually, they, for safety's sake, detain the defendant and try to establish who they have, because they don't know why someone is giving a name that's been false. It's a safety. After they finally are able to identify him, he's still obstructive. It can be so difficult when you're first in here earlier today, reading about or listening to the elements he read to you, to really get an idea of what it looks like to see what's happening in life. That's what it looks like. Now, you have to hold me to my burden of proving beyond a reasonable doubt that those crimes were committed. I believe that I have met that burden, and I ask you to find the defendant guilty on both counts. Thank you for your time.
Would you like to make a formal statement?
All right. So, like I said before, I do like to study law. I bring back the statement of being a criminal, being charged criminal of a crime. If I understand correctly, the crime consists of a bodily injury. Somebody gets injured. Somebody injured. So, other than that, some fines maybe. I can pay those, definitely. But to the whole thing about the furnishing falsified documentation, we could argue about that all day, but it's their rule basically. I could always take it back to the Universal Declaration of Indigenous Peoples, which is native, or we want to put it, allowed to nationality, which is what I am more presenting those documentations, having the certified documents in hand, showing them the laws. Won't help none, but it might. Only thing I could say is I stand by what I've done, and I don't see anything wrong that I did. That's all.
Thank you. Okay. Any re-argument or you're all set?
I'll make it brief, Your Honor. as you've heard 3.5 times, I'm gonna say again from everyone, the court has instructed you on what the law is for this matter. The law is what the court has said it is. You'll have it in front of you in a short while. There is no requirement in any of the elements for either of these crimes for there to be a bodily injury. And so again, I ask you to take what you've heard today, what you've seen, and look at those elements and find the defendant guilty on both. Thank you.
Thank you. Okay, one of you all gets to go home because you were the alternate in case someone didn't make it through the day. Juror number 5, thank you for your service. You may be excused. The remaining of you will be excused to deliberate. You can take your notes with you. Again, remember to select a 4-person. If you would like to review any of the exhibits that was admitted, your 4-person can notify by knocking on the door and passing a note. You're not allowed to speak directly to the court officer or to the judge or to the lawyers. And then try your best to work out your differences if those arise, and to come to a unanimous agreement if possible. All rise. I'm going to swear you in, David. Okay, my understanding is that you have a verdict. Okay, are you the 4-person?
Yes.
Okay, if you can read your verdict, please. It's up to you.
On count 1, not guilty. On count 2, guilty.
Did you want the jury polled?
Yes, Your Honor, please.
Okay, juror number 1, is that your true and accurate verdict? Juror number 2, is that your true and accurate verdict? Number 3, is that your true verdict? Number 4, is that your true verdict? Number 5 was that number 5. Juror number 6, is that your true verdict?
Yes.
And juror number 7, is that your true verdict?
Yes.
Okay, I want to thank each of you for appearing today and for being attentive and diligent in your work to make sure that the Justice Department does what they're supposed to do. The system does not work without willing participants like yourself. So thank you again. If you would like to stay behind and talk to the attorneys, sometimes they like to ask questions, but it's completely up to you if you'd like to stay. Otherwise, you are free to go, and thank you again for your service. Okay, so that was not guilty on count 1, guilty on count 2, which is furnishing false information. And my understanding, sir, is that you're only being held on this, correct?
Yes. Well, so
It looks like you've been in custody on this since February 10th with a 510% fine. You'll credit your time, sir. You're all set. Thank you.
Well, we have come to the end of the trial for Mr. Skates, and we see that there was a not guilty verdict on count 1 and a guilty verdict on count 2. Count 1 was the obstructing a police officer, and I can kind of understand why they said not guilty, because even though the officers said that, you know, he was kind of pulling or whatever have you, it didn't really seem like it was much there as we watched the body cam footage. So I can understand why the jury didn't really go for that, as far as, you know, charge or as far as finding him guilty for that. I can kind of understand that. And second, you know, the whole failing to identify himself, obviously, with the whole Aaron Bay stuff, they found him guilty on that. But this case is over, and as always, I always tell you guys, anything pop up from any sovereign citizens that we've covered in the past, I don't care if it's an old case that I've never seen before, I will share it here. So I wanted to make sure I shared this trial with you guys, and shout out once again to Sovereign Citizen Chronicles for sharing this trial with me. And I did not forget about you guys on the Jadon Young trial, and also the Max Pritchett. I know you guys had asked me about that. Even though it's an older trial, many of you wanted it uploaded and chopped into pieces where you can just kind of, just take it in without having to watch the whole thing. So I need to do that myself in order to get that done. But just hopefully I can get those out to you. I like doing the trials. I think they're really great. Just to kind of see the aftermath of everything that we see in the courtroom and out on these body cam footages at these stops or wherever these things are happening. So I'll try to get that out to you guys, but nevertheless, we'll keep the compilations going. And when we get to those trials, we'll drop them right in the middle of the compilations, in between the days of the compilations, like we did with Mr. Skates. And that is all for now, guys. Thank you as always. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. See you guys soon, and God bless.